22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the Commonwealth, relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm a special prosecutor on the Aidan Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradel for Aidan Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradel. Good morning, Mr. Kearney.
And Mark Federer for Mr. Kearney. Good morning, Your Honor.
Good morning, Attorney Federer.
And good morning, Judge. Attorney David Yannetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Reed.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little.
Let me just start with a disclaimer. As many of you have pointed out in the comments, I'm not a lawyer. I just like researching. I don't claim to be good at it either. I just find I have questions that I want answered, and so I go and try and find the answers. And it doesn't mean that the answers that I found match how lawyers might operate. What I am, though, is I'm Karen. And what Karen has that I probably wouldn't is the public support to finance what she's going through. So in that sense, I'm probably more like all of you guys out there watching my videos. Ordinary people who, when put in Karen's situation, probably wouldn't have the resources to even get a bite at the apple at SCOTUS level. So I just wanted to be clear, I'm not a lawyer, I just know how I feel about injustice. And who do we look to when we feel the state is using its power against us? Of course, we look to judges, right? They're not just referees who keep an even playing field. They're the constitutional gatekeepers of evidence of the Constitution itself. And it's not just us who look to the judges for this role, it's also the jury. I hear a lot of people saying that they wish Judge Sisitsky was on Karen Reed's case. And I get it. We all thought, finally, a judge said something. We saw him rebuke Brennan, which doesn't happen often, and we thought, yes, the judge sees through it. But is this emotional relief? Finally, Brennan got called out. Is this just optics over substance? After months and years, for some of us, of watching Arnie Bev interrupt the defence, berate them in open court, side with the Commonwealth, deny basic motions while granting lopsided ones for the prosecution, we've literally been conditioned to expect hostility and imbalance in every judicial interaction. And then enter Sisitsky, a not Canoni judge, who doesn't actively insult the defence, seems willing to listen, publicly rebukes Brennan, even if it's only mildly, and expresses some discomfort with how the Commonwealth is compiling materials. And suddenly the bar feels like it's been raised. But here's the thing. This is what systems do under stress. They condition observers to celebrate the absence of overt abuse, as if it's actual reform. And so this is why I ask you to consider, is Judge Sisitsky a hero or a villain in this story? Was his Rule 17 hearing a win for Karen Reed, or do we just think it is because it's such a contrast to what we're accustomed to? Did we just get so used to Canoni's courtroom as a battlefield and we forgot what neutrality is supposed to look like? And that means we're settling for a performance and not a fix. Is this moment just as dangerous, if not more so, because it feels better while the same rot continues underneath? Does this change in tone equate to justice? And in this video, I'm going to explain to you why it probably doesn't, and why this is probably not as much of a win as we think it is.
Those are what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I understand that from a legal significance, that's probably true, but does it resolve the actual harm? I'm not talking about the harm to Karen Reid in whether she could or couldn't sit in on the hearing. What Sisitsky was basically saying is we're not here today to decide whether this material can be admitted at trial. We're only here to decide if the prosecution has shown good cause to subpoena it at all. But my question is, does the prosecution have the right to any of that information in the first place? So technically, the Lampron rule allows the defence or prosecution to subpoena documents from third parties before trial, and only if 1. the documents are relevant, 2. the party issuing the subpoena shows specificity and necessity, and 3. it's not just a fishing expedition. So technically, the Lampron hearing, as Judge Sisitsky says, is held to evaluate those 3 factors before any material is handed over. But it does not address the tainted nature of the material, that privileged communications may already have been accessed before proper taint procedures were ever followed. His assertion that he's only here to decide whether the prosecution can ask for these materials, not whether they're admissible, is technically correct under Lampron and from a procedural standpoint, but it completely avoids the deeper due process concern. The Lampron standard doesn't ask how the material was obtained. And if it was accessed before any legal process was in place, that's a constitutional violation, not a procedural one. And while Jackson didn't disagree that raising it later in a motion to suppress or motion in limine before trial may have been procedurally correct, the issue is the ruling here by Judge Sisitsky will undoubtedly result in irreversible damage, because the prosecution's approach in the Reid case may have already been informed by materials that they had access to before any legal process like the taint team was in place. The entire point of a taint team is to prevent this material from ever influencing the prosecution. So if the court waits until trial to deal with the taint, it's already too late to protect due process. By narrowly framing this as a Lampron issue, Sisitsky has essentially said, I'm not going to deal with your constitutional concerns right now, leaving the issue unresolved. Judge Sisitsky absolutely had the judicial discretion to raise concerns about fruit of the poisonous tree, and could have, on his own accord, curtailed or even denied the Commonwealth's Rule 17 based on a number of things. The most obvious being his judicial discretion and gatekeeping duties. When evidence may have been obtained unethically or illegally, i.e. without a taint team, or it originates from a separate prosecution where due process has not been followed, or when it could prejudice a defendant in a different trial, he could easily have addressed those issues with Brennan to demonstrate neutrality in this situation. The fruit of the poisonous tree doctrine, as I understand it, means that if evidence is obtained unlawfully, for example, a warrantless search, a Fourth Amendment violation, or privilege breaches, any derivative evidence is also inadmissible. This is especially true in criminal trials, where liberty is at stake. We all know that Karen and Aiden's devices were accessed and searched without a proper taint team. We know that because in the last video I showed you, Adam Lally was talking about the content of those devices in Karen's pre-trial hearings before Tim Bradel asked for the taint team to be put in place in Carney's case. This means there was no firewall between the team investigating or prosecuting Carney and those handling Karen's case. ADA Lally submitted a 300-page document trying to tie Karen to Aiden Carney's protests long before Tim Bradel started raising the issue of the taint team, having never been appointed in Carney's case. This is textbook poisonous tree stuff. So why didn't Sisitsky, in his judicial discretion, take this into account? Judges don't just interpret the law, they protect the accused. And Sisitsky had every right to say, this smells rotten, and send the Commonwealth packing. By labelling it a Lampron issue only, Sisitsky is treating it like a dry subpoena formality. He's ignoring the constitutional infection in how the data was acquired, handled, and packaged. Put simply, He's helping the prosecution launder data they never had legal access to in the first place. The fact that it even made it to a Lampron hearing is the issue. And this is why I wonder if he's a hero or a villain. When a judge steps in for another, especially in an intertwined high-stakes criminal case like this, they're not just a placeholder. They assume full authority and responsibility for whatever they are asked to rule on. For those who don't realise it, Carney's original judge is on vacation. So the very moment Judge Sisitsky accepted jurisdiction over the Rule 17 dispute under Reed's docket, he became responsible for understanding its entire context. That includes reviewing prior rulings and filings, where it clearly shows the information from those devices was already used in Karen Reed's case before Mr. Bradel asked Judge Doolan to put the taint team in place. So, if Sisitsky was actually doing his job and not just a favour for Auntie Bev, he would have investigated whether serious legal issues like taint, privilege or due process violations are in play. This taint issue wasn't hidden. There were plenty of red flags in the hearing transcript and filings that should have prompted Sisitsky to dig deeper. If not at the original Rule 17 hearing, then most definitely at the emergency hearing, where Bradel explicitly raised privilege and the conflict between Cosgrove and Brennan. Any judge worth their robe, especially one stepping into a hornet's nest like this, should have said, wait a minute, was this data obtained lawfully? Are there ethical lines being crossed here? Under Massachusetts Code of Judicial Conduct Rule 2.7, judges must ensure that proceedings are fair and impartial, those things we knew about, but also informed. And that includes knowing when an issue might implicate suppression or exclusion of evidence, considering if continuing the hearing without context might prejudice a defendant's rights, and acknowledging that prosecutors from the same DA's office are now acting as their own taint team, i.e. in Morrissey's communications. That point alone is reason enough for Sisitsky to stop the hearing and request an evidentiary hearing or special master to assess what's going on. The bottom line is, Sisitsky should not have ruled without looking into the taint issue. He either didn't do his homework before stepping into the case, or he was briefed and chose to ignore it to avoid rocking the boat, or he was asked to do it by Auntie Bev. Which brings us to the next question. Why is Brennan's Rule 17 motion being called under Karen Reed's docket in Auntie Bev's court, but Auntie Bev's not on the bench? Well, I suspect that was strategy on Brennan's part. They brought it to Canoni because she's proven willing to entertain their legal absurdities. They're not prosecuting Carney in this motion. They're attempting to access evidence from him for use in Reed's trial. So procedurally, they do file it under her docket. This is standard in theory, but controversial in this case because of the way it's being weaponized and how it skirts due process safeguards. But that still doesn't answer why Canoni isn't the one hearing it, even though it's on her docket. And that's because the motion targets someone who is not a party to the case, Aidan Carney, and Carney's case has been in a different court, at Stoughton. But his compliance with this subpoena is being adjudicated here. Canoni likely recused herself. Why? In order to, wait for it, remove the appearance of impropriety for the first time ever. It does, however, seem that she is taking advantage of the fact that Judge Doolan, who normally oversees Carney's case, is on vacation. So it's being heard by Sisitsky, not Canoni, because it concerns enforcement of a third-party subpoena targeting Carney, who is not a direct party. And while it is legally permissible in a narrow sense, it's still extremely controversial because of the circumstances, intent, and potential rights violated. But what it does do is it allows Brennan to launder otherwise illegally obtained evidence through a Rule 17 motion so that when it's presented at trial in Karen Reed's case, it looks clean. So no, I don't believe Judge Sisitsky is the hero everyone wants to paint him out to be. Sure, he gave us a performative spanking, which everyone celebrated, and while we're all busy cheering, we missed the fact that he still gave Brennan what he asked for. A ruling in court that cleans up the otherwise tainted material that Morrissey had in his possession. In a nutshell, Brennan and Canoni literally took advantage of Judge Doolan being on vacation. Would Judge Doolan have ruled the same way, or would he have considered the fact that this material was tainted when it was originally used in Reed's case to try and tie her to Aidan Carney for the purpose of trying to get her bond revoked? To answer this, let's go back and revisit what Doolan actually did. Doolan authorised a taint team after Carney's devices had already been seized and searched. Communications between Carney and Reed had already been referenced in Commonwealth filings, and evidence from those devices had already been strategically used in Reed's case. By doing this, Doolan didn't prevent contamination, he rubber-stamped it retroactively. That's not how taint teams are supposed to work. Taint teams, also sometimes called filter teams, are meant to separate privileged from non-privileged material before prosecutors review any seized data. They also prevent the prosecution from weaponising attorney-client communications, journalist-source interactions, or any other protected content. By allowing the DA's office to view the communications first, exploiting them in Karen Reed's hearing, and only after the fact convene a taint team, it defeats the purpose entirely. This is what's referred to in federal practice and legal academia as evidence laundering, the process by which improperly obtained or privileged evidence is passed through a facade of procedural validation to render it admissible or usable. Doolan's after-the-fact taint team allowed the Commonwealth to retroactively clean evidence they had no business reviewing in the first place. And it's worse because Doolan knew the devices had already been searched without judicial supervision. There was no independent neutral. The Commonwealth was again acting as its own gatekeeper. So, when Sisitsky inherited the Rule 17 hearing from Doolan, this should have been front and centre in his briefing. The taint team was a sham. It came too late and was staffed by conflicted parties. Evidence from Carney and Reed's phone was already introduced in pretrial arguments to target Reed's bond conditions. And Canoni allowed it in Trial 1.0 by permitting testimony about witness intimidation, despite prior agreement to exclude it. Sisitsky not recognising the poisoned well and not intervening just carries Doolan's judicial misconduct forward under a new name. Under any other name, Doolan's move facilitated evidence laundering. Both he and Sisitsky gave the Commonwealth a retroactive green light to do what they've already done, invade privileged communication and turn it into a strategic narrative building. So now we have not one, not two, but 3 Norfolk County judges all facilitating evidence laundering. This isn't just a story about one bad judge or one bad ruling. This is a judicial relay race where each baton pass hides the fingerprints of Morrissey's misconduct. Let's be real. What we're seeing here isn't incompetence. It's coordination between the judiciary and the DA's office. It's systemic misconduct passed down the line like a hot potato. Each judge builds the illusion of legitimacy on the back of the last. Essentially, we have a chain of judges all stamping approved on documents while refusing to look at what those documents say. One starts the laundering, the next seals it, and the third pretends there's no stain at all. That's why this isn't just a case about what happened to Officer John O'Keefe. It's a case about how truth dies by 1,000 technicalities.
Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.